Hello, I'm Adam Kielich, the managing attorney of the Kielich Law Firm in Bedford, Texas. Today's short video is going to discuss flat fee legal services and how flat fee arrangements with attorneys work. Um, Basically, the way that a flat fee agreement with an attorney works is that the lawyer accepts a flat fixed payment in exchange for a specific set of legal services. By charging this fixed flat amount, the lawyer gives the client a known and predictable amount of attorney fees that will be paid out of pocket. This is essentially the opposite of the normal hourly fee arrangement. Under an hourly fee arrangement, the attorney will ask for some chunk of money up front and then bill against that advance based upon whatever the attorney's hourly rate is. And then once that initial advance runs out, the attorney will either ask for another chunk of money and repeat the process, or start billing the client on a monthly or quarterly basis, and the client will be responsible for paying out of pocket. Under that kind of arrangement, the client may have an estimate from the attorney of how much the legal services will cost, but the client will never really know how much the legal services will cost in total until all of the services have been performed and the final bill has arrived. So that flat fee arrangement gives the client an opportunity to know upfront, this is what it's going to cost, this is how I'm going to have to pay for it, and that's it. There are, of course, some other fee arrangements out there. There's contingency fee arrangements in which the attorney does not accept any kind of fee up front and does not bill the client for an actual amount, but instead collects on the back end a certain portion of whatever is recovered as a result of the case. These are common in civil claims for personal injury, sometimes in employment law, and various other kinds of civil litigation. Some attorneys will take cases on a blended type of fee arrangement in which perhaps a flat fee or a retainer is required up front as a partial payment for the legal services, and the rest of the work might be done on an hourly basis for any additional services, or in the case of litigation, the attorney may take a flat fee up front and then also take a portion of whatever's recovered as a contingency payment. There's also something that's called a retainer, and paying an attorney by retainer is sort of a confusing subject. Even lawyers tend to use this word incorrectly or in a way that's ambiguous. Under a retainer agreement, the attorney is retained for a particular dollar amount on a periodic basis in exchange for being available to perform specific services for the client. For example, it's common for businesses to put certain types of attorneys on retainer so that those attorneys will be available whenever they need them for certain functions. For example, a small business may put an attorney on retainer to provide legal advice on various business matters, employment issues, licenses, dealing with city codes, whatever. They may pay the attorney, say, $5,000 per month, and in exchange, the attorney agrees to be available to help that business with whatever legal services are necessary during that month, perhaps up to a certain hourly limit, at which point maybe an hourly rate kicks in afterwards. Under this retainer agreement, the attorney is really being paid for blocking out that time for the client rather than the specific services provided during that block of time. Some attorneys working under an hourly basis will ask for an advance on the fees and call it a retainer, but that's not actually correct. if the attorney is billing by the hour against the money paid up front, it's an advance rather than a retainer. Now, there are situations where an attorney can take payment as a retainer, bill against it in sort of a hypothetical manner on the hourly rate, and then start working hourly above it. But in that situation, the attorney is really accepting a true retainer for giving the client a block of time and then billing beyond it. That can be kind of confusing. It's easy to look at a fee agreement and not really know which is the case, whether it's a true retainer agreement or merely an advance on fees. But maybe that's getting a little too far out for this video. The important thing to understand is just the difference between the way that flat fee services are billed versus some of the other arrangements out there. It's also worth pointing out that in certain areas of law, it's either prohibited or impractical to adopt some of these different types of fee agreements. For example, in family law work, there's really only one area in which a contingency fee agreement is permitted, and that's in recovery of judgments based upon a family law case, and that's really only applicable in the case of child support enforcements, where the amount of unpaid support is reduced to a monetary judgment. In the case of a divorce or most custody proceedings, a contingency fee agreement is not permitted by the disciplinary rules. In some types of law, some of these fee agreements really don't work. In litigation, it often doesn't make sense to have a retainer agreement. But again, maybe that's going a little too far out here. Just focusing back in on the flat fee agreement, the kinds of clients and the types of cases where it's most probable to see a flat fee case is where it's easy for the attorney to determine what kinds of services are going to be provided. This will include transactional work, drafting documents, filing documents for clients, providing certain kinds of advice on processes. Uncontested litigation can also often be done on a flat fee basis. Many criminal defense attorneys work on a flat fee basis. In more complex or more severe criminal cases, it's common to see the attorney charge a flat fee by the stage of the case, so that the client is paying on the basis of how deep into the process the case actually goes, rather than paying all the way out for a trial up front. And that can be helpful for a lot of criminal defendants who tend not to have a lot of money to throw at an attorney for no reason. On the other hand, there's a lot of clients and cases where flat fee just doesn't work. This is most common in contested types of litigation, both civil and in family cases. And that's because it's very difficult to predict how a particular case is going to play out, because you have one or more, well, you have at least two parties in litigation which have independent ideas, independent desires, independent results that they're looking for, and those different attitudes about the case can result in the two parties not reaching an agreement early on. Cases may go to trial, which can be very expensive. Even if one party wants to settle the whole way through, there's no way to force the other party into a settlement. So it's very difficult to charge a flat fee knowing that a case might settle tomorrow, or it might be resolved after a trial and appeals years down the road. So it just doesn't make sense in those kind of cases to charge a flat fee. We certainly don't want to charge a client with the idea that a case might be appealed and go on for years as a flat fee, and then have that case settle within a few months. and vice versa. We also don't want to accept a flat fee assuming the case is going to settle right away, and then we're still hanging on to that case years down the road. That can seem sort of troubling to clients, that we're not able to just predict those fees or how long a case is going to go. And the analogy that I would offer is, if you think about somebody who comes by to mow your yard, they might tell you it's $20 for the yard. They'll go to your neighbor, it's $20 for the yard. The yards might be different sizes. One might be a little easier to mow than the other. One might have been cut more recently. So the person mowing the yard can look at the yard, quickly assess how long should this take, and more or less the yard's going to take a set amount of time to mow. And after doing multiple yards, even with some yards taking a little longer than others, that person is going to have an average of $20 per yard based upon the time spent. On the other hand, imagine that same scenario, but in each yard, the yard fought back against being mowed. That's a strange idea, of course, but if maybe the weeds in the yard avoided the mower, and so some yards took an extremely long amount of time versus others, it would be very difficult for that person to say, hey, $20 per yard no matter what. This is the problem that we face in contested litigation. We're not just performing a service for you where we know what's going to happen and there's nobody antagonistic, nobody is throwing in a severe monkey wrench that's going to prevent us from being able to resolve your claims. In litigation, we have a party which has just as much control over what goes on in the process, just as much control over whether the case settles, whether it goes to trial, whether it's appealed. And so there can be a lot of work in between an easy case and a very difficult case. And there's just not an easy way in most cases to break down those fees into a flat fee basis. If you're talking to an attorney about a case, whether it's something you're going to litigate or it's some sort of other legal service you need, like a document drafted, you should talk to the attorney about different fee arrangements and make sure that whatever you're paying that attorney is based upon what makes the most sense for what that attorney is providing you.